Welcome to LegalBid, your fast pass for choosing legal help. In this video, we will provide an overview of an alternative dispute resolution process called mediation. Mediation is a resolution method where a neutral party, called a mediator, helps two parties to a dispute come to an agreed-upon solution or settlement. The mediator's role is to act as a facilitator, as opposed to a decision-maker. Accepting a settlement or solution through mediation is voluntary, although sometimes courts, such as Arizona's Family Court, will strongly encourage and in some cases require parties in pending cases to at least attempt to resolve some or all of their issues in mediation before proceeding to court or as part of pre-trial procedures. Real estate, construction, and other contracts will often contain provisions that require parties to mediate their disputes arising under those contracts before proceeding to arbitration or trial. Mediation saves time, avoids the higher costs of taking a case to trial, and lightens the calendar load of courts, so parties are encouraged to mediate their disputes in most civil suits. If you are asked by a party with whom you are in a dispute to participate in mediation, or if you are encouraged or required by the judge in a court case in which you are a plaintiff or a defendant to mediate, the information in this video will be useful to you. The first step in mediating a dispute is to select a mediator. Most courts have lists of mediators that are approved by the court, but parties are typically free to select their own mediator so long as the parties agree. The usual procedure will involve the parties on each side submitting their preferred list of 2 to 3 mediators to the other side for consideration, and eventually settling on a mediator they both feel will be fair to their side. Mediators can be attorneys, former judges, or neutral third parties with experience in the type of industry out of which the dispute arose. Once a mediator has been selected, they will consult with the parties to agree on a date when mediation can take place. One of the advantages of mediation is that it can be conducted much sooner and more quickly than a typical trial. Once the date has been selected, the mediator will ask the parties to prepare mediation statements and submit those statements to the mediator before the mediation date. There is no formal discovery process in mediation, but if the parties agree, the mediation statements can be exchanged between them before mediation. If the parties are participating in mediation before a lawsuit has been filed or early in the life of the lawsuit, the parties may even choose to exchange basic documents, photographs, and summaries of witnesses they would call at trial and summaries of the testimony those witnesses would provide. The advantage of this limited exchange of documents is to give both sides a realistic idea of the strength of their own case as compared to the other side. Mediations often take place at the mediator's office or, if it is more convenient for the parties, at some other mutually agreed-upon location. The mediation will begin with a statement from the mediator outlining the process and emphasizing the confidentiality of the proceedings. The discussions that take place during mediation and how close or far the parties came to reaching an agreement during an unsuccessful mediation cannot be introduced at a later trial. In addition, the mediator cannot be called on to testify in trial as to what occurred during mediation. Parties may bring their respective attorneys, but are not required to. No witnesses are present at mediation. After the mediator explains how the mediation will work, each side to the dispute presents their mediation statement, which identifies the party and summarizes their claims. The statement should give a brief overview of the facts and should clarify what the party sees as the issues in the case. After both sides have the opportunity to present their statements, the mediator will split the parties into separate rooms and spend time with each party individually, going back and forth between them to help them negotiate their claims. The mediator's job is to remain neutral while helping the opposing sides evaluate the strengths and weaknesses of their case. At the end of the mediation, the case may be completely resolved, or only some of the claims in the case may be resolved. A mediator cannot make a binding decision for the parties in a mediation. However, if the parties agree to a settlement of the entire case, or agree to a partial settlement of some of the claims in the case, The mediator prepares a settlement agreement containing all of the agreed upon terms to be signed by the parties and will often prepare the agreement while the parties are still present at the mediation. If a lawsuit was filed by one of the parties prior to the mediation, the settlement agreement will be filed in the case and is binding on the parties. If the settlement completely resolves the dispute between the parties, the agreement will provide that the lawsuit will be dismissed. If a lawsuit has not been filed yet, the signed settlement agreement will be an enforceable contract between the parties. The main advantage of resolving disputes in mediation instead of a courtroom is that the parties retain control of important aspects of the process. They agree on who the mediator will be and can even choose an expert in their particular field if the dispute involves a specialized industry contract. The mediation process is faster and costs far less than a full trial, even if the mediation continues over multiple days. The costs of a mediation are usually shared equally between the parties and range from a few $100s to a few $1,000s per day, whereas the cost of a full trial can far exceed those amounts. Mediation is only one of two popular alternative dispute resolution options. The other option is arbitration. If you are involved in a dispute that will be arbitrated, please see our video here on Legal Bid for a full overview of arbitration.